At the time of his death, he had a claim pending seeking a higher disability rating for his psychiatric condition to include a TDIU rating. This court has already held in a memorandum decision that the board violated 7104A when it considered the TDIU question in the first instance, and we ask this panel to reaffirm that ruling. The question here is whether there was any harm in that error. I want to start by reiterating that under Bernard's plain text interpretation of 7104A, the board has jurisdiction over all questions in a matter, but lacks authority to adjudicate any question that was not subject to initial decision by the AOJ. And in this case, the question in particular being the TDIU rating or entitlement to a TDIU rating is extremely fact heavy. And as we emphasized in our supplemental briefing, those questions, those factual questions have different review depending on whether the board is looking at it or the court. And so when the board looks at facts in the first instance, violating 7104A's requirement for one review on appeal, the only option available to the claimant is to come to this court and argue for clear error, which is a very high burden, as all who practice here know.
So, Mr. Hawkins, I want to ask you about the Secretary's argument that the Bernard waiver kind of prejudice schema doesn't really apply to the AMA because obviously, under the legacy system, there's a lot of evidentiary development happened after, and it wasn't always immediately clear to people what issues the board may kind of end up addressing on appeal. And then obviously there wasn't, if the board kind of adverse decision couldn't be challenged any longer within VA. I mean, you have to collaterally attack it later. So what do you say about that the sort of AMA kind of overhaul of a lot of the procedures has kind of put to rest a lot of the concerns that animated Bernard?
My first response, Your Honor, is that there's no indication in the AMA that Congress intended to modify or change 7104A. In fact, the language is exactly the same. And it makes sense that if Congress had wanted to make that change, it would have amended 7104A. Now, we acknowledge that there were significant changes, primarily what evidence is considered, and the application of the duty to assist, but none of those touches on whether the board is allowed to, under the plain text of 7104A, consider a factual question or any other question in a matter that the AOJ had not yet done. The language in 7104A is clear, and as Bernard interpreted it.
But you realize, I mean, that has the potential to be really unwieldy. I mean, are you saying every single factual matter that the RO has not addressed, they'd have to remand? I mean, it would just be like a ping pong game of endless remands. What would you say about that? I mean, I can't imagine that that's good, practically speaking, for veterans.
Well, again, Your Honor, it's that system, that procedure has been in place well before the AMA. When Congress initially looked at evidence, for instance, at the board, they were finding that the board was remanding evidence or remanding appeals because of new evidence, and they amended the statute that says the board is allowed to, I believe it was in 2012, that the board is allowed to, in the first instance, look at evidence unless the claimant says that they don't want that. That was the requirement for one review on appeal remained. And so the idea that just because the board can look at evidence in the first instance, that they're also allowed to circumvent one review on appeal doesn't hold water in light of that change in law. And with respect to the duty to assist, that really has nothing to do with whether the factual questions have been determined. Now, it of course can inform some of the facts, and development of evidence will certainly inform the adjudicator on what the fact is. But simply because the duty to assist no longer applies after the RO decision does not mean that Congress intended for the board to take over the role of the AOJ. And we have to remember that the reason for this procedural protection, as indicated in Bernard and reaffirmed, I think, in multiple, in this court's precedent afterwards, is that there's these procedural protections for the claimant. And I emphasize, particularly under the facts of this case, the most important two are: one, notice of a determination, letting the VA or letting the claimant know that the VA had made a finding of some fact or even a conclusion of law with those adequate information, and two, the standard of review. And after the AMA, the VA amended its regulations to put in place what we all kind of already assumed, but they explicitly said in the regulations that the board performs a de novo review. That's 20.801. And so this de novo review is really important, particularly to factual questions. And I would just point out as well, so that's really the most important aspect of this right that's in 7104A, is to have. Oh,
Mr. Dojaquez, what about section 7113's provision that the board shall consider in the first instance evidence submitted by the appellant at the board hearing and within 90 days thereafter? Doesn't that statutory scheme itself enable the board to address the appellant's TDIU contentions?
Well, it certainly, I don't know that statutory provision, Your Honor, really changes anything. As I mentioned, in 2012, Congress amended the statute to allow the board in the first instance to consider evidence, with an option for the claimant to ask for a remand for a supplemental statement of the case on that evidence. So the idea that the board is going to consider evidence submitted to it in the first instance is nothing new and has been around at least for a decade, or nearly a decade by the time the AMA came around. But again, that statute did not touch on the right to one review on appeal, in particular of factual questions. And the other aspect of this with notice is 5104 was heavily amended to give a more robust information to the claimants, to include some of the things that were brought up in the opening brief, in law and determinations, and to some degree, favorable findings. But without a decision or an adjudication by these questions within the matter, the claimant loses the ability to retain or obtain the 5104 notice that the AMA is really the driving force, the engine behind the AMA. And the board under Greer does not support or does not supply that 5104 notice. So when we get to the board with a question that has not been addressed by the AOJ, the veteran does not get notice under the statute and does not get the benefit of a de novo review, particularly of fact findings, and is now limited to essentially is limited to arguing for clear error, as Mrs. Allison has been subject.
I mean, how is that clear error? I mean, de novo review just means, there's no deference to any earlier adjudication. I mean, why clear error means the board would be essentially saying, okay, I may disagree with that RO finding, but I cannot discern any error in it. Whereas the board de novo means they do it kind of tabula rasa, as if there were never any claim done before. How is that clear error?
Well, that's exactly, Your Honor. The board is not looking for clear error. The board is making a new determination. But again, it's a de novo review of any findings by the AOJ that, with the benefit of those findings, with the benefit of the 5104 robust notice under the AMA, the claimant has other options, so to speak. And this court's precedent in case law dealing with all of the AMA really emphasizes the choice, and the real reason for the AMA is to allow for these choices. But all of them rely upon.
Since Ms. Allison specifically asked that a request for TDIU be considered part and parcel of the current appeal, how can she complain that the board did as she asked and decided the TDIU issue?
Your Honor, she asking for something that is already the law is not a request for a waiver of any rights. TDIU is always and has always been a question within the matter of the appropriate rating, and that goes back at least as far as Rice and even earlier. So just asking for something that she already has a right to have, which is that the board take jurisdiction of the TDIU rating, or at least consider as part of the rating a TDIU rating, is not and cannot be really interpreted as a waiver of any kind of right to one review on appeal. The law is quite clear that TDIU is just a rating, and it's no different than if she had requested any other scheduler rating. So all she was doing with that was simply alerting the board to the fact that the evidence also supports entitlement to a TDIU rating, and that she expected an adjudication from the secretary. And so, you know, in looking back at Comer and some of the other Federal Circuit precedent, TDIU raised either implicitly by the record or explicitly by the veteran is part of a rating whenever it's raised, whenever the rating issue is presented to the board with an appeal. And so, again, requesting that they adjudicate it goes to the jurisdiction of the board, does not go to the authority that Bernard distinguished and that Jarrell also distinguished, although kind of obliquely, that once the matter is before the board, all questions to include the appropriate rating under any applicable law or potentially applicable law is within the jurisdiction of the board.
Let me ask you this, Mr. Dojaquez. What would be the statutory or regulatory authority for the board to remand a case? Because obviously some veterans might object to the fact that, you know, it took them a long time for to get their claim in front of the board, and rather than adjudicating something, the board is remanding it. Now, I know under regulation they can remand if further development is needed, right? If they find that the duty assist hasn't been satisfied and something's needed. What you're describing is almost more like a, which is an inability to adjudicate something in the first instance, so you refer it to another party for an initial adjudication. So back to my question, what is the statutory or regulatory authority that would allow the board to adjudicate something that fell within the scope of a claim on appeal?
I want to make sure I understand your question, Under, because you kind of said two things there. So the statutory authority, you're asking the statutory regulatory authority to remand a question in a matter.
Yeah, because someone could just as easily challenge it from the other direction and say the board had a duty to adjudicate whatever, you know, you're saying some new facts, something that hasn't been addressed by the adjudicator. And I'm imagining a challenge where somebody says, well, what authority does the board have to do, essentially relinquish this and send it back to an RO? I wanted the board to adjudicate it. Meaning, you know, things are processes are governed by regulation, they're governed by statute. So
I believe the statutory authority, Your Honor, is 7104A. It doesn't explicitly give, it doesn't explicitly tell the board to remand a question in the matter, but it's implicit and implied within its mandate that the question is subject to one review on appeal. And so when the specific question has not been addressed, the board has to recognize that it has no authority under 7104A, although it does have jurisdiction, and to remand the specific question for that initial one review on appeal. The secretary promulgated its regulations in identifying that remands for duty to assist errors were required, which is from the statute. There's no dispute in that. They also created this other regulation, the subsection that allows it to, it may remand for other reasons. We don't really rely upon that. I'm not really sure what that regulation means, and there's been some questions in various decisions from this court over the past couple of years on what that exactly means. But that part of the regulation we don't rely upon, mostly because it requires a finding that it would result in a possible entitlement to benefits or something along those lines. But we do believe that 7104A, inherent within its restriction on the board's ability or authority to review questions that have not been subject to AOJ decision or adjudication, to inherently give it that authority to remand for that review.
The appellant's supplemental brief appears to contend that fairness requires a waiver by the appellant for the board to address questions that the AOJ did not. If the argument is that the board denied the appellant fair process, please explain how that is so.
So, yes, thank you, Your Honor. So that's the other side of this, is that even though the board is normally not allowed to, certainly the claimant can ask it to specifically and waive that review. But simply raising the question is not the equivalent of waiving one review on appeal. And if the board has any question about whether the waiver, the submission or any communication was a waiver, we look at Bill Hars that reaffirms the board's the hearing officer's obligations to fully explain the issues to the appellant. And when this was presented at the hearing, the board member could have simply just asked, are you waiving this? Do you understand what a waiver is? They didn't do that. And we would note too that the appellant was not represented by an attorney at the hearing. There was a representative, but it was not an attorney. And we know from this court and the Federal Circuit's precedent that we treat non-attorney represented claimants differently. But regardless, Bill Hars reaffirms the board's obligation with a hearing to fully explain these issues. Bernard and the general counsel opinion that Bernard discussed in there really emphasized the idea that the board has to reach out to the appellant when it's considering doing this and either make a determination that the veteran will not be harmed or ask the veteran if they want to waive it. There's nothing that stops the board from just reaching out with a letter and says, we're looking at this. We're looking at remanding this because of our restrictions. Do you want to wait? Do you want to have this remanded and have to wait for this to get back to the board, or do you waive this remand? So to your question, Judge Toth.
Is there anything left factually for VA to address in this case? What would be accomplished if we remanded?
So a remand, Your Honor, if we look at the record on page 11 and 12, these are the very fact-heavy determinations that were done by the board that were never done by the AOJ. And these are specific to a TDIU rating. Now, in some instances, a lot of the same fact-finding will apply to different ratings. And so we don't really see this as an issue when the question is merely a scheduler rating, because a lot of the findings are gonna complement or apply to the various percentages that are underneath the diagnostic code. Where we see this in most distinguished is in a TDIU, where we're looking at work history. We're looking at what skills and education and training the veteran had, what kinds of those are transferable to different jobs, and how does the individual disabilities affect not only on the average impairment as the diagnostic code contemplates, but specifically in getting and keeping a job, which is what's contemplated by 4.16. And so these kinds of questions are what make up the ultimate determination of whether a veteran is unemployable and entitled to a TDIU rating. And so, again, all of these questions should have been addressed by the AOJ in the first instance so that Mrs. Allison could have received notice, could have received the de novo review by the board of those. And I think in all of our experience, we know that the more eyes that look at these, the better refined the issues become and a better decision that comes out, as opposed to the board looking at it without the benefit of the AOJ review and then having to argue for clear error at the court, which is a nearly impossible burden to overcome. So, and Judge Toth or Judge J.
So basically, just for those to understand what's going on here, what happens when you file your claim, as many of you know, you file your claim, and it goes through the process. And then if you get an unfavorable decision, now this one specifically is TDIU. You get an unfavorable decision, and then it goes to, you could push it to the Board of Veterans Appeals. And then if it's still a negative or unfavorable decision, you could then kick it to the U.S. Court of Appeals on veterans claims. So there's two different courts. I just kind of a higher, lower court type of a situation. When the attorney is referencing AOJ, that is the agency of jurisdiction. And within the VA, remember, this is all a very legal process as evidenced by judges looking at VA cases and looking at precedent and all of that type of stuff. I cannot hammer home enough how important it is to get your evidence solid up front. Take the time, don't cut corners, take your time, build your evidence, and supply everything that you need to support your claim. And in fact, in 3 different ways you should do this. And it's just important to talk about it because otherwise you end up in this situation. So number 1, you need to make sure that you're providing the evidence for the number 1 thing, service connection, right? You need to prove the nexus. The second thing that you need to prove, most people just stop there, trying to just prove the service connection, and that's it. There's more. There's 2 other things that you should absolutely focus on when you are developing your claim to avoid circumstances like this. The second one is the appropriate rating, right? So service connection, the appropriate rating, which means you're supplying the evidence that would warrant whatever rating is on the rating schedule using VA rating schedule terminology. So it's very clear to the rater. You want to make sure that you supply them with what they need. The last one here, the third thing that you really need to focus on is in the event that you have long-lasting conditions that have been in place for years, 5 years, 10 years long, you really want to demonstrate that you've had these conditions for that amount of time. A lot of people don't say it. The fact is that if you solidly prove that you've had a condition X that's service connected, you meet all the criteria for this rating, and you prove that it's been in existence for 5, 6, 7, 10 years with solid medical evidence that outlines that, you are most likely going to get a static rating, which means the VA is not going to do a future exam. It means that you're going to get the appropriate rating on the rating schedule for that service-connected condition. All of those things are super important, and it saves you heartache going and trying to fix things later. So the AOJ, again, that jurisdiction within the VA is typically going to be the regional office where all this stuff. So when he's referencing AOJ, that's what he's referring to. And again, this is regarding a TDIU claim that apparently didn't go through. Now, the courts have 3 different things that they can do. They can deny, they can approve, or they can remand, which means push it back to the VA to gather more information so they can make a decision. With that, let's go ahead and jump back into it.
To your question about fair process, which is, I think now we due process under Bill Haar's, this was not, there was no fair or due process here because the process that was required was to receive and obtain an adjudication by the AOJ of all of these findings of fact, all of these questions in the rating matter from the AOJ so that she can appeal them to the board, and that did not happen. And we really want to emphasize, and you know, we've said this quite a bit, and I'll keep repeating it, but the primary harm that Mrs. Allison is suffering is that she's having to ask this court to overturn these findings of fact, which is not fair to her under that, and is really not the process that was promised by Congress in 7104A.
I'm going to ask you, Mr. Dojaquez, I'm kind of sort of gaming this out in my head as to how this works. But so under 7113, obviously people are allowed to submit evidence to the board. And, you know, sometimes this happens. The evidence will suggest maybe a different theory of entitlement for a claim that's already on appeal. So something like, if you imagine somebody's got a depression claim, it was denied on a direct basis, and then they submit some evidence that suggests maybe it's secondary to something else, right? So a different theory, but fundamentally the same claim. How would that work under the scenario you're proposing? They would have to refer that to the RO or remand it to the RO to address because there's been no fact finding, even though it would be the same claim that's on appeal, and they're looking at the evidence they're allowed to look at under 7113. How would that work?
So that is the default, Your Honor. But I would just distinguish between a referral and a remand. I believe it was Young v. Shinseki. I hope I didn't misstate that precedent, but it distinguished between a remand in which the board does have jurisdiction and a referral in which it does not. And so the board in that instance would, by default, have to remand the question that you raised, where it was secondary to or some other way of finding that it was related to service.
I mean, a lot of our case, sorry to interrupt you, but like a lot of our case law is we sort of, all this referral stuff was based on regulation. And so we often kind of described it as jurisdictional because the secretary delegated, refer extra schedule or refer this. None of that's jurisdictional. So in a sense, I mean, they may violate their own regulations by not referring something, but to me, referral is the more, I say remand is a fine term, but effectively what's happening is you're passing something along, not because of an error, but just because you sort of lack the delegation to kind of hear in the first instance.
Well, under that definition of referral, then yes, John, I think that would be appropriate. But we have to deal with what we have in precedent now, which is where the court has called referral something that they didn't have a jurisdiction over, and this is where something was raised, a CUE or some other entirely different issue, which I don't believe the AMA really contemplates for that anymore necessarily. But even though that's the default, again. The veteran can waive this review by the AOJ. Carpenter Charter does that on a routine basis, and I know a lot of other attorneys will ask the board, we don't want a remand, we just want a decision, and they can certainly do that because it is a claims processing rule. And I don't think there's any dispute that can be waived. And the board can also go ahead and adjudicate it. In your hypothetical, Your Honor, if the board can grant it, there's no reason why they can't, because even though they may have violated it, Bernard recognizes that it's a harmless error because the full benefit was granted. That, of course, assumes that the actual full benefit was granted, and in the case of a service connection matter, then that would be a full grant. But certainly in some rating issues, there may be additional things, ancillary benefits and so on, that the board may have overlooked, which, again, that's the third option, is for the board to just reach out to the veteran and say, do you want to waive this? I want to consider this, but I want to remand this back or refer it back for adjudication. But if you don't want me to, then we don't have to. We can certainly
That's a bit
ask.
unwieldy. I mean, how long do they have to wait for a response? I mean, because I imagine this kind of could introduce.
So just real quick, I want to throw out there some numbers. We can all agree that the VA doesn't always get it right. And this is highlighted or evidenced by the Board of Veterans Appeals. Okay, now what we're watching here is actually the U.S. Court of Appeals for Veterans Claims. So this is the next highest one. But at the board level, the one down, still judges, of the claims that are submitted to the Board of Veterans Appeals, generally between 34 to 41% are approved. That's a big number. And on that note, it's really shows that the VA is missing something somewhere. If they're getting overturned at this point, or there's some additional steps that the VA could do prior to going to the Board of Veterans Appeals. If a lot of these things were generally approved after remand and digging and getting more information and what have you, maybe that could have happened sooner. The ones that I would love to know the numbers on would be somebody who filed a claim with the VA, filed an HLR and was denied, so they supplied no additional evidence. Then they decided to push it to the board and said, I'm not going to supply any more evidence. Everything's in the file. How many of those actually get approved at the board level, meaning that the VA clearly missed it twice in that example? So that's a big number. Now, what happens is from the Board of Veterans Appeals to the U.S. Court of Appeals for Veterans Claims, the numbers drop drastically. Why? Well, because a set of judges or a judge had already looked at this specific situation and now, in this case, denied it. And now that veteran has now pushed it to the U.S. Court of Appeals for Veterans Claims. And I pulled this up. It says the Court of Appeals for Veterans Claims has a much lower success rate, with the judges issuing a final judgment on less than 3% of cases that are appealed to the court. The hill gets steeper, in other words, right? So the more denials you get, the harder it is to dig yourself out of it. And again, I said this earlier, I'm just going to kind of paraphrase it here. This is why it is so imperative that we supply everything we can to support our claim for those three things: service connection, correct rating, and longevity of your condition to develop a static nature, if applicable. Those things are so instrumental in your claim and future heartache. The more times you get denied, essentially, the deeper the hole is that you have to dig yourself out of. All right, so let's dive back into this and see what's happening here.
Anytime you introduce complexity into a high volume system, you're going to get delay, and so that's kind of what I'm wrestling with in the back of my mind. Obviously, beyond just legally, practically, this would introduce quite a bit of complexity into the system.
It may, Your Honor, but I think that the Secretary can certainly make a regulation that gives a reasonable amount of time and subject to, any challenges at the courts on whether that is in fact reasonable. The VA has for years, had pretty standard response time, 60, 90 days, 1 year. Obviously, I don't think a year is appropriate for this kind of a question. When cases come back from the court, they by default give 90 days to submit any additional argument. I don't think that a 90-day response time is out of the question. I would even suggest that maybe a 30 or 60-day time frame is probably reasonable in a lot of cases, subject to the specifics of the individual veteran. But it's not going to, I don't anticipate that it would cause such significant disruption in the process to simply reach out and say, do you want me to do this right now? And if not, then we can send it back. And the disruption that goes along with going to court and overturning these, or even sending it back to the AOJ for initial development. Yes, the board gets that off their plate, but the Secretary as an agency now has to deal with the referral, the questions should the board send it back. So I think that it's a reasonable rule that the board can simply just ask and should ask. And that's what Bernard says. Bernard very clearly says, and the VA's OGC opinion, by the way, going back to the 90s, recognized that there's no reason why the board can't reach out to the claimant. The fair process doctrine talks specifically, and looking at Simmons in particular, looking at harmless or prejudicial error, talks about this team kind of concept with the veteran and the VA. This is not an adversarial system. This is the VA and the veteran working hand in hand in tandem to do what they can under the laws to help the veteran prove these claims. And it certainly isn't helpful if the board takes over something without any indication to the veteran that they're going to do so, knowing that it's going to cut off a very substantial right to de novo review, to notice under 5104, without at least putting the veteran on notice and getting their input on it.
Thank you, Mr. Dojaquez. I see we're over time. Judge Falvey, do you have any questions? Okay. Judge Jaquith? Okay. Thank you, Mr. Dojaquez. Counsel?
Your Honor, it may please the court should affirm the decision on appeal and find that the board does not violate Section 7104A when adjudicating and denying entitlement to TDIU in the first instance. And the alternative, the court should find that appellant waived her right to initial AOJ decision in the matter. Given the choices that appellant made when appealing this in the AMA, the board was required to address evidence of unemployability in the first instance, and the board was only required to remand in order to remedy a duty to assist violation at the AOJ level. While appellant argues that under Bernard, the board was required to obtain a waiver if it could not grant this benefit in full, this argument ignores the decades that have followed Bernard, development both in case law and in statute. So for example, in disabled American veterans, the Federal Circuit noted that the board does not violate appellant's rights under 7104 when addressing law that the AOJ did not. The TDIU regulation here is
What
simply
about,
law.
what about facts, though? I mean, Mr. Hawkins argued that, addressing facts in the first instance sort of takes away someone's right to de novo review. I guess the review part of de novo review.
Yes, Your Honor. So there is no blanket prohibition on factual findings in the first instance, and Congress, when passing 7113, required the board to address evidence in the first instance. On appeal in the AMA system, the record is closed except for the evidence that appellant wishes to submit to the adjudicator directly. And the board has its reasons or bases requirement. It is required to address that evidence, make factual findings, and address applicable regulations. So there would be no violation there, Your Honor.
Can't that submission of evidence reveal a duty to assist shortcoming?
Your Honor, there currently is a pending panel that gets at this question. But in all cases, the focus is on the existence of an error at the AOJ level. Appellant here is not arguing that the AOJ erred in the initial consideration of her claim. So it is important to keep that in mind.
What's in that vein, I guess, what's the significance of the failure of the Veterans Law judge who authored the March 2023 board decision on appeal to note that the prior board member in December of 2021 relied on a November 2019 opinion from the veteran's longtime physician that as a result of his problems with hearing, the veteran had developed significant paranoia in that he couldn't hear what people were saying, so he thought they were talking badly about him, and both the veteran and the appellant described the veteran's hearing loss as a workplace problem, including leading to coworkers laughing at him, ridiculing him, resulting in frustration, embarrassment, and heartbreak when he couldn't work. The kind of actual engagement that we'd expect from the regional office?
Yes, sir, Your Honor. So in December 2021, after the board granted entitlement to service connection, there was a rating decision that assessed the occupational and social impairment caused by this now service-connected acquired adjustment disorder. So the RO made factual findings regarding the level of occupational impairment, found that the level of occupational impairment was not total, Your Honor.
What's the basis for the board's determination that the veteran's psychiatric disorder would most impact him as it relates to forgetfulness? Is that a medical determination?
That's based on the evidence of record, Your Honor.
What evidence is there in the record that compares the impact of the veteran's forgetfulness with his anger and paranoia? Doesn't the medical evidence focus on the veteran's frustration, anger, and paranoia? Is forgetfulness more impactful than anger and paranoia?
Your Honor, the board was making a judgment about the impact of those symptoms specifically on the workplace. And again, sort of, it's important to note that the rating and the measured occupational impairment here is not being challenged. The question is whether the board had jurisdiction over TDIU, not the merits of the TDIU decision itself.
It doesn't seem like there's any question about whether the board had jurisdiction over TDIU. The parties agree that it does.
Yes, Your Honor.
But but that leaves the question of how that jurisdiction is exercised, right?
Yes, Your Honor. This court has long held, in Rice, Phillips, and other cases, that TDIU is part and parcel of a claim both for initial rating and an increased rating. And Appellant's reliance on Bernard to suggest that the board had jurisdiction but no authority to deny entitlement to TDIU, ignores developments in case law and statute and the review options and evidentiary windows applicable in the AMA, Your Honor.
How is that inconsistent with the AMA?
Bernard, Your Honor?
Yes. And there's been a handful, maybe a half dozen even, of presidential court opinions since Bernard that have reaffirmed it.
Your Honor, so there are what one presidential opinion by the Federal Circuit after Bernard is disabled American veterans, noting that the court can address law, in this case, the TDIU regulation in the first instance without violating rights to 7104. And it's important to note that the AMA
this isn't principally a legal issue in this in the case we have before us. It's a factual one.
Yes, Your Honor. Also important to note that when passing the AMA, the court greatly limited the board's authority to remand the remedy that Mr. Dojaquez is seeking. So the board is required only to remand, to remedy a duty to assist error, and another potential remand must involve a failure below. This is not the case in which new evidence can lead to the need for new factual development. It is not in the legacy system in which evidentiary development continues to claim. New evidence have warranted the development of other evidence, which would have warranted a remand. But that's just not possible in the system that Congress created here, Your Honor.
Isn't it possible under the AMA, and perhaps having occurred here, that the board could have concluded that properly under 2802 and 5103A that there was a shortcoming in the AOJ's attention to reasonably raised TDIU claim or contention or part and parcel of the rating challenge?
The board could have, Your Honor, but that is discretionary. And again, appellant has not argued that there is an error below or identified an error below.
Well, what's not discretionary is, at least arguably not discretionary. Certainly, this is the appellant's argument that the board had a duty and obligation under Bernard that it failed to fulfill or even acknowledge.
And no, Your Honor. So it's important to note that Bernard involved reopening a previously denied claim. So the initial, which that informs the decision of Bernard, Your Honor. So the initial rating decision denied reopening the claim. It focused on whether evidence, met the required standard. And the Veterans Board hearing on appeal specifically discussed the standard for reopening a claim. It did not address the merits of the issue in that case, which was entitlement to service connection for multiple sclerosis. So here, the veteran, the claimant, she submitted the evidence she wished to submit. She and a representative both discussed this issue at the hearing. The board member presiding over the hearing identified TDIU as an issue on appeal. At the hearing, the appellant's representative asked the board to grant entitlement to TDIU. So unlike Bernard, in which the hearing and the initial rating decision were here, the disability rating, everyone.
Why shouldn't we echo Judge Bartley's 2019 Bakulis decision that nothing in appellant's asking that the board grant TDIU waives their right to agency appellate review of an adverse TDIU determination?
Yes, Your Honor. Two important things to note. That is a memorandum decision, and also that the decision on appeal there predates the AMA and restrictions on the board's ability to remand. So again, it may be applicable somewhere. It's not applicable here, Your Honor.
I want to ask you, counsel, what happens when a claimant submits evidence to the board in along the lines of 7113, so timely, within 60 days or something, and it basically is evidence for a totally new claim, right? Not on appeal, not part of the NOD, not part of the original claim, so clearly outside the scope. What does VA do with those? Do they just ignore them, or?
That may be a case in which referral is appropriate, Your Honor.
So sometimes they would refer them, but they have no statutory duty to adjudicate it.
Yes, Your Honor. Again, and then TDIU is part and parcel of an appeal. That also happens, for example, when an upstream issue is on appeal, and downstream issues need to be adjudicated later. So initially, the first time this was before the board, the appellant was challenging the denial of entitlement to service connection. The board granted service connection. The board had no authority to, in the first instance, assign a rating or an effective date. So yeah, there are cases in which, again, there are issues raised that the board needs to send down to the AOJ.
What's the impact of fair process on whether the board's required to consider whether the appellant would be prejudiced by the board addressing an issue in the first instance?
Yes, Your Honor. So important to, when we're talking about fair process, it's important to clarify what we're talking about here. Pursuant to the Federal Circuit's holding in Francis v. McDonough, physical harms. And so that would be the Matthew v. Eldridge factors. There has been no due process requirement that Mr. in the shape of what Mr. Dojaquez is arguing is required. So yeah, this satisfies constitutional due process and is largely determined by the statutes and process that Congress has created. Again, it's important to note that Congress, in passing the AMA, has given appellants different options. There are 3 options for appealing a less than fully favorable rating decision. Appellant first chose higher level review and then chose to appeal to the board. Appellant did not choose a third option, a supplemental claim, which would have allowed her to present this evidence before the AOJ in the first instance. And so the board has no authority to reroute the claim. It is bound by the choices that a claimant makes.
I'd like to ask you a question about 7104. That 7104 is the board's statutory jurisdictional, it's the jurisdictional statute of the board. Is that something that's waivable? Then if that's a jurisdictional provision, is that something that's waivable?
Your Honor, rights under 7104 are waivable because the one appeal to the secretary is a claims processing rule, Your Honor.
Okay, despite the fact that it's called the board's jurisdiction.
So the right to one review on appeal specifically is waivable, Your Honor. So there needs to be an initial decision by the regional office in order to confer jurisdiction on the board. Whether an issue is presented that should be remanded pursuant to 7104 is a waivable question, Your Honor.
I mean, certainly
The
the
evidence of waiver here.
Sorry, Your Honor, can you repeat that?
What's the evidence of waiver here?
Oh, yes, Your Honor. So first, in the notice of disagreement, there's the cover letter to the notice of disagreement. Appellant's representative specifically requested that TDIU be considered as part and parcel of the appeal. Again, in the board hearing, the veterans representative asked the board to grant entitlement to TDIU in a cover letter attached to the vocational assessment. The veterans representative again asked the board to consider that evidence in the first instance. So yes, we have evidence of a waiver. If a right existed here, we have evidence of a waiver that was made knowingly, voluntarily, and intelligently.
So back to Bakulis, you reject that decision's conclusion that seeking a grant of TDIU is not a waiver of the veteran's right to one review on appeal.
Your Honor, again, we note that there is no right to be waived here, but if there were, yes, as the board, as 7113 states, the board is required to consider this evidence in argument in the first instance, and the board's reasons or bases requirement requires it to address and make factual findings regarding all potentially applicable regulations. So once there is evidence that could suggest entitlement to TDIU, the board is required to adjudicate and make factual findings regarding whether appellant is entitled to a 100% rating under the regulation 4.16. So it's not a tenable distinction argue that a claimant is waiving consideration of the evidence, but not not waiving any rights regarding adjudication as well.
So would this be an accurate statement of the Secretary's position that that the board can adjudicate in the first instance anything that falls within the scope of a claim that is on appeal, right? Short of maybe downstream issues like effective dates, assigning a rating, if the issue was service connection, right?
Yes, Your Honor. So basically, as this court noted in Vargas Gonzalez v. Principi, an NOD cannot express disagreement with an issue not decided. In a standard claim, right? Disability compensation claim, there are three issues here: service connection and effective date, disability rating. So here, only disability rating was on appeal. The board was required to address all questions within the scope of the disability rating, but for example, the effective date here was not on appeal.
Yeah, well, I mean, it strikes me the difference between the sides here comes down to the kind of the granularity, by which we sort of deal with. Is it facts? Is it issues? Is it claims? What's the scope? The RO obviously does not have a reasons and bases requirement, right? So we know what the rulings are, but we would not know all the factors that in the record that they considered. But the statement of the case, right, is designed to kind of give some notice as to the factors that the regional office considered, right?
Oh yes, in the legacy system, yes. But it's probably helpful to consider this as the court has discussed, TDIU is a rating option. So if in an unrelated case, if the board assigns entitlement to a 30% rating based on a certain diagnostic code, on appeal, the appellant argues that the board, the rating, the RO applied the incorrect diagnostic code, and in fact, these symptoms warrant entitlement to a higher rating under a different code. The board is therefore required to address the applicability of that regulation in the first instance. Again, it would be untenable for the board to remand every time a veteran raises the applicability of a different diagnostic.
I mean, I'm looking at, I don't know if you've got the CFR in front of you. I'm looking at 20.802, right? Which
Yes.
is, it seems like, the secretary is obligated to remand for correction of error, right? And so the first sentence of that looks like it's mandatory, shall remand for duty to assist violations. The second sentence looks like it's may remand for correction of any other error. So maybe that's discretionary, maybe, but it's all predicated on error. Is there any authority to remand things merely kind of in the first instance, like absent a showing of error?
No, Your Honor. The focus is on error and specifically on focus in the initial adjudication. That is in large part the purpose of the AMA. A veteran has an ability to take evidence or arguments directly to the board, or a veteran may file a supplemental claim and present them first to the RO. The board cannot reroute the claim.
So it looks like we Judge Falvey, do you have any more questions?
No, I don't.
Okay, Judge Jaquith, do you have any more questions?
No, I don't. Thanks.
Okay.
Then I will conclude, and the Secretary respectfully asks that the court affirm the decision on appeal. Thank you.
Thank you. Mr. Dojaquez.
Thank you, Your Honor. So I want to start with both Bernard and more importantly, Jarrell. Jarrell, page 331 of that decision, citing to fit 7 properly appealed, the board is vested with the jurisdiction to review all questions in the matter. And then it continues at the beginning of page 333, once the board has jurisdiction, it has authority to address all issues related to that claim, even those not previously decided, citing Bernard. And then it says to exercise this authority with regard to questions or issues not previously addressed by the RO. In the first instance, however, the board must secure a waiver from a claimant or otherwise determine that there would be no prejudice to the claimant. So this Drueckhammer was issued in 2006, Bernard in 1993. So for nearly 30 years, this had been the law. 2012, the Congress gave the board the authority to review evidence in the first instance unless the claimant asked for a remand for that purpose. So when Congress modified the statutes and implemented the AMA, it was aware of this case from Drueckhammer, and a panel from Bernard. That was the established law. Congress legislates.
Let me ask you, and I understand. I want to pose to you what I just posed to the Secretary's Counsel, which is it's kind of about the scope of what is on appeal, right? And so it strikes me, I mean, you want it to be very granular, right? Which is pretty much any fact that hasn't been decided first by the RO. And the Secretary is arguing more, it's just the kind of the scope of a claim itself or any issue that's specifically cited on the NOD. If it's more granular, how would we ascertain what the RO has in fact looked at? You know, if you get down to the individual level as opposed to like a theory of service connection maybe, or whether extra scheduler is warranted, some issue that could kind of be raised in the first instance. Would we assess it by looking at the SOC and saying anything that's outside the scope of the SOC would be deemed raised in the first instance by the board?
Certainly, it's very difficult when we're looking at facts, Your Honor, and in the legacy with the statement of the case and in the AMA with the 5104 notice, the statutes require detail. True in the legacy, the rating decision and even the AOJ does not have a reasons or bases requirement as the board does.
So has there ever been case law that linked the kind of board's adjudicatory capacity, let's call it, with have they delimited it by the contents of the SOC in the way that you're describing, which is to say to venture beyond the SOC in the first instance would be problematic? Is there anything, any case or anything you can think of that goes there?
Well, yes, sir. Yes, Your Honor. Bernard, that was Bernard. The Secretary, I think, misreads Bernard to say that because they have jurisdiction, they can just go ahead and decide the questions. But Bernard actually remanded for the board to determine whether the veteran would be harmed, just as Bakulis did, whether there is harm. And Bernard was the ultimate ruling was Bernard was a remand of that specific issue because the AOJ.
Wasn't Bernard, it adjudicated a claim on which an earlier kind of motion for new and material evidence had been denied, right? I mean, it was a claim that wasn't within the NOD. It's not just a matter of like going beyond the SOC to kind of address a new theory, right?
No, I don't think that's how Bernard understood the statute, Your Honor, and that's certainly not how Comer and some of the subsequent case law. The statute distinguishes between a matter and questions within the matter. The matter in Bernard was entitlement to benefits for that condition. And one of those questions was, at least in that procedural posture, whether new and material evidence had been submitted to reopen. The AOJ said no. The board said yes, but we're going to deny it. And the court said, once you got past yes, you had to either get a waiver, find the veteran is not harmed, or send it back for one review.
Right, but that's because that would have been a claim. I guess if the NOD was just the procedural, right? That's what you're saying. It was they complained about the denial of the motion for new material evidence over and against adjudicating the substance of the claim itself.
Well, and the claim itself, Your Honor, and Witkowski actually touches on this some, which was issued just a couple weeks ago, in that the claim construction itself, and DeHart also was a panel from last year, looks at what is the nature of a claim. And the claim itself is a request for those specific benefits for the psychiatric condition. Once it's been granted, the rating now becomes the matter that was adjudicated by the VA. And DeHart in particular, and I don't necessarily subscribe to this, but at least for the purposes of this case, the facts are somewhat similar to DeHart's analysis of TDIU being different. And Rice and Comer and Roberson and all these cases recognize that TDIU is differently treated because it's a way of obtaining an appropriate rating. And so I don't think that the secretary would dispute that if Mr. Allison was seeking, or Mrs. Allison was seeking a different scheduler rating, whether, then it would be within the jurisdiction of this appeal. But for whatever reason, the secretary gets hung up on TDIU, but it's nothing special. It's just a rating. It's a regulation that allows the board to assign a specific rating outside of Part 4, well, outside of the diagnostic codes. So the issue or matter, as the statute calls it, is the appropriate rating. One question in there and one applicable or potentially applicable law is 4.16 in assigning a TDIU rating. But just to finish my thought, this case law existed when Congress amended the statutes. Congress didn't do anything to change 7104A. Had Congress wanted to remove this one review on appeal right, it would have done so. The fact that 7113 was included, which allows initial review of evidence, is irrelevant because, again, in 2012, the board already had that right. All 7113 did was remove the right to ask for a remand for the evidence. And I would just point out that normally when new evidence is submitted, it typically would address or speak to the specific questions that were addressed by the AOJ in the decision. And so when it does that, then the board can consider that evidence and, to the extent within the confines of 7104A, make findings of fact, review the VA's decisions de novo, and determine what those facts are. But when it addresses something different, as in here, TDIU, then a different analysis applies.
Mr. Hawkins, I see you're up against your time. You spent some of rebuttal answering my questions. So do you want 2 more minutes to, if you have any?
I do, Your Honor. Thank you.
Okay, well, great. Great. 2 more minutes.
So the other aspect of the Secretary's argument is that by closing off the duty to assist somehow changed anything. Again, there's nothing in there that changes 7104A or even speaks to the board's authority to consider questions in the matter that had not been subject to one review. The 20.802 was included to recognize bases for remand for errors by the AOJ. This was triggered in large degree because of the duty to assist restrictions. But again, there's nothing in any of the statutes that Congress meant to change the holding in Bernard, the holding in Jarrell that interpreted the statute. This is a statutory interpretation. Had Congress wanted to change it, they would have done so. To the extent that they overlooked it, that's just how the statute is written right now. Last point on evidence of waiver, we would just reemphasize, as Judge Jaquith pointed out, Bokulis, although it was a legacy decision, the holding there is that the asking for a benefit is not the same as a waiver. And the Secretary just points to giving evidence and asking for an adjudication that is not contemplated by any of the case law on waiver. We didn't get to that, but we would just ask you to consider our supplemental brief in finding that it's a very fact-heavy determination, and there was no fact-finding done by the board on whether anything had been waived. All that the board did was, at best, is implicitly found that there was a waiver, although more than likely I don't think they recognize that they should have considered waiver. So Mrs. Allison asked that this court recognize, one, that the TDIU question is within the matter of the rating for her husband's psych rating, that 2, the board did have jurisdiction to consider it, but 3 lacked authority absent a waiver or a finding of harmless error. We asked that it be remanded for the board to make those determinations on prejudice and waiver.
Great. Thank you, counsel. This case is submitted for consideration and adjourned.
All right. With that, that concludes it. The bottom line is that not getting it right the first time can result in a nightmare of a process. Many of you have felt that by maybe not getting it right with your initial claim. I think the key here is making it as easy as possible for the VA to rule in your favor. It is so important, and I said it twice during this video. I'm going to say it a third time. The 3 things that you need to focus on when you're putting together your claim for anything is 1, the service connectability of it all, providing that evidence in a very solid manner, clear, concise, very easy to understand. You need to, secondly, make sure that you are providing all of the evidence needed to not just rule in your favor, but to rule the appropriate rating. Should you be a 10%, a 30%, a 50%, for example? Well, you're going to have to figure it out with the schedule of ratings, work with your doctor, have your doctor complete, if applicable, a DBQ, disability benefits questionnaire. If your doctor can't, won't, or doesn't understand what you're looking for, realize that a DBQ is a blank form. It means nothing. It is garbage. It only matters what's written in it. And if you just give a DBQ to your doctor and walk away, that doctor doesn't know that they're supposed to really detail it toward the rating schedule. So if your doctor can't, won't, or doesn't, reach out to American Medical Experts. Super solid. They're board certified doctors. They can help out with all of that stuff if you need it. If you need a nexus letter, which helps you get that service connection, if that's required to prove your case, then they also do that, and they have a $200 off Nexus letters through November 11th. So get the free consultation scheduled. Nexus letters, for those that don't know, a Nexus is required. A Nexus letter is not required. A Nexus is proving to the VA that your condition either manifested during your time in service, was caused by your time in service, or made worse by your time in service, and proving that. Now, if you can't, let's give you a great example of what it would look like to prove that. You got diagnosed for condition X while you were in service. The date of that diagnosis or incident or whatever it is that caused your ailment, the date being inside your time in service creates the nexus. You're solid. The problem is when you don't document it while you're in and you get out of service, and now you're trying to build a bridge back to prove that your condition manifested or as a result of your time in service. And in some cases, you're going to need that nexus letter to be provided as medical evidence on your behalf. So again, nexus letters, they're running a special through November 11th, Veterans Day, $200 off if you schedule your free consultation with them. So the first 2 things, getting your service connection, making sure that you're rated appropriately. And the third thing, which is often left out, is if you have a condition that has been present with you for more than 5 years or is deemed static in nature, you really want to make sure that you get that documentation from your doctor, medical provider, that clearly states that your condition is deemed static. It is not going to get better. You've had it for X number of years, or just by the nature of the condition or disease or whatever it is, it is what it is. It's chronic and it is static and it's not going to get any better. In fact, it might get worse. If that is the case, you need to absolutely make sure that you work with your doctor to document that verbiage. Why? Because now, if you supply those 3 things that I said, documenting that static nature, documenting the appropriate level of rating as it relates to the rating schedule and all of the information that shows the nexus so you can get service connected. If you supply a claim that has all of that stuff clearly documented, not only are you going to get service connected for the condition, you're going to get the appropriate rating. So you don't need to file an HLR. You don't need to file a supplemental claim. You don't need to fight the VA to get the appropriate rating. You're not going to get lowballed. You're getting the appropriate rating. And then on top of that, your condition should be deemed static by the VA. And why is that important? Because then the VA will not, or should not schedule a re-examination for you for that condition. Now, why is that important? Well, when your conditions add up to a 100% VA funny math, and you have enough conditions there at the 100% to that are all labeled as static in nature, now that is what turns into permanent and total. So with that, thanks for watching. I appreciate you very much. If you cannot find a free accredited resource out there, feel free to reach out to us, Evidence-Based VA Claims. We're here to help you, and we will offer you a free email consultation, and we guarantee that if we take on your case, that we will get you an increase in your ratings. So with that, thanks again. I appreciate everyone. Have a great one. And remember, if we don't take care of each other, something went wrong.